Good afternoon. It's Sunday the 8th of September 2024 and the weather has got a bit not just as nice as it was, a bit windy and cold, but no rain. Enoch Burke, the 8th of the 9th 2024. There are an awful lot of comments on this subject and I'd like to deal with it now and get it out of the way. And I have reflected on it in quite a bit. I would have to first of all preface what I'm saying is that I'm not I'm not a lawyer, I'm not employed as a lawyer, and the opinion I give is my personal opinion and I can't be held accountable for how it's used. But it seems to me that there is the Unfair Dismissals Act, an Irish piece of legislation, which deals with unfair dismissals. And it deals with unfair constructive dismissals. So essentially what it means is that if the employer dismisses the employee without good reason, that's illegal. And it also seems to me that if the employer makes the conditions of work for the employee so onerous or so impossible that the employee has no option only to leave the job, that act is broken. And now, funny enough, as far as I can see, the Unfair Dismissals Act states that gender of all things and gender identity and all this gender thing and we'd say gay and lesbians and all this, that's covered. But also is covered one's religious conviction. And the question has been asked there by several contributors and commenters on my previous videos. What if the teacher was an Islam teacher, a Muslim teacher? Would he be forced to call a boy they? So between the two, it would look more like constructive dismissal than unfair dismissal, in that Enoch Burke's pay continued. But if they keep paying the employee, but create conditions such as warning him not to come to school, and create such conditions that he has no option, that he's left with the situation of being paid without any knowledge of what's going to happen, no decision, how long will he be left outside, what's he supposed to do, what will happen to his career, if he gets an opportunity of employment in another school, should he go? He's given no answers in this way. Now somebody else posted that he was confrontational, and I cannot answer that at all. So I'm going to assume maybe he was confrontational or whatever. But the point I'm making is not that. If he was confrontational, or if I was the bus driver that I've said in previous videos, and I am awkward and difficult, there comes a point when that should be documented and it's for the employer to deal with it and to deal with it fair and square. And the whole law is all about fair procedure. So the cause for the complaint against the employee should be set out, right? So the other thing is, if you look at what he appears to have been told to do, is to call this by they. Now, if I kicked the bucket and made me will and left you a cow, and the cow arrived in the lorry and put her out on your back lawn, you now have a cow. You do what you like with the cow, cards and all. You can sell it or keep it or do what you want, or milk it. Right. And you were referring to about somebody asked you, what sort of a cow is that? And you described the cow and you said it's a white cow and a good cow enough, quiet, really quiet. And they have horns. Well, you wouldn't say they have horns for a single cow. They is a plural, as has been rightly pointed out. If the school felt that this child should have been called a she, a her, then maybe they felt that was going too far. Maybe they felt that he'd have grounds to sue them because it's a boy. Maybe they felt that calling it they was a way out to avoid calling him. In any event, it's a physical impossibility to refer to a single living person animal or other thing as they. They is a plural. Now, you could say, I have cows. Now, I do have cows now, and they're out on grass this evening. So they are out on grass. That means they're all out on grass. Right? But supposing I go up now and I see one of them is in season. She'd like to see the bull. I wouldn't say they are in season. I'd say the big white one, number 78, is in season. Or she is in season. I wouldn't say he is in season, but if there's a transgender issue involved, they might make me say he for the cow instead of she, but they can't make you say they, because they is a plural. So they're asking Enoch Burke to do something or to say something which is impossible. Now, the right way to handle this, in my view, would have been for him to lodge a complaint with the Labour Relations Court, or whatever courts, or I'd write letters to the department, to everything, and fix responsibility somewhere. You can't just leave it impossible for an employee to continue in his or her employment without some reason. Now, the next thing is there some Department of Education guidelines? Are there any guidelines on how to handle this? What do they say? Now, I'd go back to my old bugbear. Education is not covered in the Strategic Environmental Assessment Directive because it doesn't involve digging up land or building or anything like that. It's in the hands of the government. So, have they given any guidelines? But if they did do guidelines, which if we doing it other than on the cheap, I made a video before about it being on the cheap, if they did guidelines, well then the guidelines would have to be thought out, and they'd have to decide what to do with the various cultures that's in Ireland. Could they make a separate law for a Muslim school than they do for a Christian school? And I would say no, because the Constitution forbids any kind of discrimination on grounds of religion. See, so there you are. And I'd say that both the Muslim, the Protestant religion, the Catholic religions, they're all registered religions with whatever charitable way they register for getting their tax-free things. I'd say they're all registered. Now, what could Mr. Burke do? Well, the first thing I would have done was make my complaint to every department. Make a full complaint in writing and get a reply, and keep that reply and see what's in it. What can they say? They probably would say it's up to each individual school to set their own standards. Well then, you'd have to ask the question, can the department do that? Can they allow schools to set their own standard in everything? They don't allow them to set their own standard on the curriculum. Well, so corporal punishment was abolished in national schools. Can they set their own standard for them? So you'd have a bit of thinking on that. The other thing is then he might have a claim against the state, the school itself. Who made this rule? Let whoever made the rule give the evidence in the witness box. And the simple question I would do if I was the barrister is, what does they mean? It's a plural. Is it a pronoun? Or whatever you call it. It's not going to go since I studied language and grammar. So he was expected to describe a single living organism as they. It wasn't two boys, it wasn't two children, it wasn't 22, it was one. And you see, when you don't tackle these things at the root, and it would have cost very little to tackle it by complaints originally, if you got nowhere, it might come to the point where you'd have to go to court. And that can be difficult because you need, for some cases, we got quotes, you need a solicitor, a junior counsel and a senior counsel. And it's 40 grand to start off. However, I think a case like that, an individual human rights case, you might get away with a solicitor and a junior counsel. And it would have been very interesting to see what this law is. We know damn well that where you have the Fine Gael, Fianna Fáil, Sinn Féin and the Greens, they'll avoid the responsibility every way they can. And I know the Attorney General has given wrong advice to government on environmental law. or if they haven't given wrong advice, their advice has been ignored. I'm not privy to all of that. Now, the other thing is, and this is a bit like the environmental stuff, you see, you get a person that's suffering from noise, as happened down in Wexford from a wind farm. I know, please don't switch off on that. I'm only making the point. They're suffering from the noise. The court has to decide all this. There has been no guidelines drawn up with scientific, acoustic, sound, engineering, or anything. There's nothing. And the European Court of Justice ruled in case C-2419 that that's unlawful, that all of those guidelines for wind farms have to be pulled down. And the result of not having it properly assessed is you have individual cases before the courts with different judges trying to scratch their head and find out what is the situation with this, what's the situation with that, when in fact it was the onus was on the state to carry out the strategic environmental assessment in the first case. If you take a public house and the guards prosecute a public house for something about having people on the premises or failure to comply with the time limit for young people on the premises, if the pub is licensed, that's all right. The judge can deal with it as a licensed premises. But if there's no license at all, the judge only can deal with it as a dwelling house or a barn. Do you get my point? When you fail to do the proper assessment at the beginning, all the problems that arise from that trickle on down the line, and they can't be solved because the original problem was never dealt with. In the case, in my opinion, of Enoch Burke, it's dragging on and it's dragging on, and nobody knows, nobody ever found out, nobody ever tested what directions were issued by the department on this issue. Probably there was none. If there was none, then what is the policy of the school? Get the school to write down the policy is to call a boy gay in certain circumstances, or not to call him gay, to call him they, They, They. And if they write that down in writing, you can go into the court and say, hold on here a minute. Sure, how can I call a single boy they? That's ridiculous. You'd probably win. And because none of that was dealt with at the basic level, you have this mess now where he's in jail and he won't yield and the school won't yield and the courts won't yield, and the courts have already decided these, and most of the things that the courts decide is done with, but this won't go away. So I'm not saying, for example, that the judge in this case could have started an inquiry into the Unfair Dismissals Act. I'm saying that the Unfair Dismissals Act and its kindred legislation and the Employment Tribunal and Appeals Tribunal and the unions, as somebody said, what happened to the unions? Why didn't the unions, they have money, why didn't they go in and test this? Of course, I would guess the reason is they're all mad woke. They're all mad woke, that'll be my opinion, but that's only my opinion. It's not individually Enoch Burke. It's about the principle that a person going about their ordinary work in an ordinary way can suddenly be hit with some ridiculous thing which makes neither sense nor reason and defies logic. And these people are supposed to use logic in their daily work. And then they try to enforce it. Does that make sense on that? I'd have been writing on them. I always do this. People mention to me all the time, I'm this, that, and that. And I get the typewriter out and I'm sick writing letters. Get it done and send it in. And I use the access to information on the environment request. I force the councils and Bord Pleanála to tell me what their policies is on certain things. And then when they realise you're doing this, they kick for touch and they won't grant anything. So you have to have them a chill factor. Now, can I just finish, and that's 14 minutes, on this. In this judgment of Harry Miller, and it is a kind of relevant in this, the big key to the Harry Miller case, Harry Miller was being monitored by the police and put on a police record, not for crime, but for non-crime hate speech or non-crime suspect opinions. In other words, the thought police was after him. He went right up to the courts, and Judge Sharp, a female judge, but considered to be a very sharp British judge, she's sharp in nature and sharp in name. That's a good one, all right. But anyway, it doesn't matter her name. But she made the point, and this is persuasive in the rest of the English-speaking world, including Ireland. She made the point that there's a chill factor. The net is so wide that the police are using this registration to frighten other people, and that is a collective suppression of the right to free speech. And Britain has the Magna Carta, which guarantees the right to a certain amount to free speech. And that is a very, very intelligent judgment. So, for example, another teacher, we'll say, up in Lisdoon, Varna, tomorrow morning might be in the same position. So they have the chill factor of knowing that if they don't go along and call the boy they, that they'll end up being laid off without pay. They'll have to be told not to come in. The whole daily routine will be upset. They may have a mortgage. They may have problems. The next thing, if they do come in and just keep coming in, they'll be sentenced to prison. So you see the point I'm making. It is a chill factor. Now, most of the lefties will not agree with a chill factor. They think the state should be able to frighten the daylights of people. And a lot of people are easy frightened and are being cowed. I'm one of the few that has put it up to them because I have education and courage. So the chill factor is very real, and that is a very, very seminal or groundbreaking judgment. Harry Miller, you'll get it there, versus Humberside Police. And he beat them. And they don't like it. They're on the internet there where the Chief Constable of the London Metropolitan Police is hemming and hawing and scratching himself. He doesn't know what to make of it. They wanted to scare everyone who holds independent views, the right to have free speech. They wanted to scare them out of it. But fair play to Harry Miller, he took them on. And there's usually always one that will take them on. And even in my own case, eventually when the whole thing about the failure to comply with the European law on the environment blows up in their faces, I'll be able to say I went into the High Court and I appealed to a judge to hold with me and say it was illegal, and the judge refused. So we have that on the record. It's people like that that help to preserve our freedom. I think I've covered everything in that. Even yet, I would imagine that 6 years, I think, that the Burke family could consider. Make sure, and this is my advice to them, cover every dot. Make sure you do every complaint and ask the reasons. Make them put it in writing. Make them say what they meant by they. They probably made a big mistake by not specifying the gender. Now, they will probably argue that we don't know what the gender of this boy feels like. He might feel like a woman, he might feel like a man, he might feel like a transsexual or whatever. We don't know, so we put in the word they. So then it will be up to the court. But at the same time, it'd be very hard to see. And it's a point of major public importance. So a person would be entitled to their costs in this too. But it's a question of major public importance for all employees. Whether you have to go against or break the laws of society and break the ordinary rules of society. For both an example, we were chatting, I was down on the farm, just down looking at bales of straw there, bales of hay the other day, and this morning actually. And the point was made, if there was a job advertised for milking cows, what do you expect to be doing milking the cows? You expect to do all the things, looking after the cows and the milk and putting them in and cleaning their udders and milking them and all that. So you know exactly what's expected of you. What if the owner decided to buy a big giraffe out of Dublin Zoo and put him into the shed with the cows and just tells you nothing and lets you off? And you have problems with it, and the giraffe is kicking and he's sticking his head here and there and he has the cows driven mad. Are you not entitled to say to your boss, I can't handle this here? Well, if the boss told you when you were take up the job, you're going to have to do this and you're going to get €5 a day extra for doing it, well, then you could probably say, well, I can't do it. It's just turned out to be too bad. That might be all right, but then he has to go off and get someone else. But if he just throws in the giraffe and you go along happily and he expects you to sort it out and you find it impossible, so what do you do then? Are you being constructively dismissed? Do you have to give up because you can't handle this damn giraffe in the middle of the thing? And if you are constructively dismissed, would the employment tribunal not have a say in that? They're cheap, you just go to them, there's no fee needed. That's why it's there. And if you sued the owner of the cows for doing this to you, would you not have to get a fair trial? But then you'll have to put money on the line, and many people are not up to that. Have I explained that fairly well? I hope that all the dots are crossed to this. I hope the school concerned has been forced to state what the policy is, what it's grounded on, where it's grounded on, what the department's view is on it. And indeed, anyone could do this. I don't know, could I apply and ask and say, I'm interested in a teaching job, what is the department's role? They don't have an obligation to tell you. That's where the access to information on the environment request comes in. They have to tell you, but you have to word it very specifically. It's not for everybody. And what if Enoch had to go in as a lay litigant? Well, you have to know the basics. You have to know the basics, I suppose. And when you'd be pleading your case there in court, you'd have to come up with a few precedents. This was held in such a thing, and this was held in such a thing. It was held down in County Cork that this was the situation, and you'd have to have a basics of this. You can't expect the defence to educate you. That is not allowable in a court. You must know the basics. But if they have some defence, they have to bring it up, and you can look it up. So that's the situation with it. Make sure the Burke family and everyone in this situation, and even anyone who wants to have a go, write to the department, ask them what's their policy in relation to this. What is their policy? Have they granted a policy? Now, this is where my channel comes in. I have no doubt some of the clever people will post underneath, and that's what I want. Please do. I think nearly all the posts and the comments are all genuine comments. I think they're absolutely great. Don't give your opinion on whether you think it's right or wrong. This is the situation. Why is the Unfair Dismissals Act and the constructive dismissal, which is part of that act, why is it not used in this particular case? Are there any guidelines for this? What are the guidelines? Who has them? What are they? And if they comply to the guidelines, and the next thing up in Clonskee and the school up there in the Muslim school and the parents don't want it, let the government deal with that. That's their mess. If they want to do this, let them carry the can. Let the officials sweat, not the teachers. Does that make sense? I think I've covered everything. We'll see you back. Comment underneath. Goodbye. Thank you.